Thank you so much. Martha, are you going to be on video today? There we go. Thank you so much. So just to let you know, judges, the parental defense is the appellee today, and Martha and Alexandra are splitting their time 6, 6, and 3 for the rebuttal. The Court of Appeals is now in session.
Hello, I'm so used to saying good morning. I can't quite get it into my head that it's a good afternoon. And let me just say that I really appreciate counsel's flexibility in accommodating the court schedule by moving these arguments to the afternoon. We have 2 cases on our argument schedule today, one at 1:30, and then we'll take a brief recess and do the other one at 3 p.m. I'm Judge Hagan. My colleagues with me today are Judge Harris and Judge Christensen Forrester. Would counsel please enter their appearances for the record, starting with the appellant?
Alexandra Marshall for the appellant mother. For the minor children.
And I don't think we've quite caught your name, Martha Pierce, guardian ad litem. Thank you.
And Kirsten Norman on behalf of the appellee and father.
Thank you, and welcome to you all. We've been doing these arguments by WebEx for quite some time now. It looks like we're going to continue that at least through September. So we usually don't have any issues. One of the things that you should know is that we do tend to try to wave at you or signal you somehow if we're about to jump in with questions, but we're a notoriously impatient bunch and might just start talking if you don't find a place to pause. When you are not arguing, if you could turn off your camera and your microphone so that we can focus on the person that's presenting arguments. But other than that, I think, and of course, these are being recorded and live streamed. So just so that you're aware of that. If we have any problems, any kind of technical issues, we will just stop, fix them, and start again. So no worries about any kind of technical issues. We will work through that. Any questions before we begin? All right. This is case 2020-0039 in re Z.C.W. Please go right ahead.
Good afternoon. May it please the court, Alexandra Marshall for the appellant mother. I'll be addressing the issues regarding best interest analysis and the proper procedural avenues for taking new evidence into account. The guardian ad litem will be addressing additional errors in the juvenile court's opinion or decision and with respect to statutory presumptions. Utah law requires that the juvenile court consider current circumstances when evaluating the best interests of children. It is a present tense analysis. This is supported by appellate court case law, dictating that the court must find that termination is in the best interest of the child. It's a holistic approach that has taken into account all of the relevant factors, including current ones. It's also supported by the statute, which dictates that termination is only appropriate when it is in the best interest of the child and is strictly necessary, not was.
Let me ask you a quick question. So as I understand your argument, do you believe that any time this court remands for a best interest analysis, because it has to be a present tense consideration, that they necessarily must hear evidence? Do we even need to reach your arguments about a motion for a new trial and the statutory argument? Or are you asking us to set down a rule that whenever a case is still pending, we've remanded to the juvenile court, the best interest analysis has to be present tense and necessarily has to consider anything that has occurred since the last time the court heard the case?
That is correct, Your Honor. We are asking this court to lay down that rule now, that best interest must be present tense, must take into account current circumstances, even on a remand. And no, this court does not have to reach the post-trial motion issues. It could remand just on that on that issue alone and just lay down that rule that the present tense analysis must be, or it is a present tense analysis.
It seems like there's two issues here if that's the route we take. The first issue is, we either agree with you or don't agree with you on whether it needs to be a present tense analysis every time when we remand for reconsideration of best interest. But the second question seems to me is what a trial court is empowered or has discretion to do in that situation. I can think of a bunch of situations where there might not be any additional evidence. You're not asking necessarily that we lay down a rule that the court always on remand has to hold a new evidentiary hearing necessarily, whether a new hearing is held or whether it's dealt with on affidavits or whether the court can just say, yeah, I'll accept all that is true and it might not matter. All that kind of thing might be up to the court, but in any event, the court needs to do whatever it does with a present tense analysis in mind. Do I have your position correct?
That's correct. It doesn't always mean that there will be new evidence, and certainly that evidence has to be brought to the attention of the juvenile court. It's not that the juvenile court has to hold a whole new trial or a whole new hearing every single time, but certainly where there is evidence and that evidence has been brought to the attention of the juvenile court, that is the circumstance that the juvenile court is required to take that evidence into account because it is a present tense analysis. And also because that is what the statute dictates. Section 78A 61108 is exactly that purpose and does make that a mandatory requirement. That is one of the avenues that Mother used here to try to get that evidence before the juvenile court. And that statute dictates that at any time, including after remand, the moving party may petition for the court to have a new hearing and hear new evidence that might affect the court's decree. And the court shall order that new hearing. Sorry.
But would you agree? I wonder about that language, because if it says if it might affect the court's decision, does that give the juvenile court discretion to say, no, the information that you have put in your affidavit would not affect my decision, so therefore I decline to hold a hearing?
It does give the juvenile court that discretion, but here it's not clear that the juvenile court actually did that analysis. The juvenile court's pretty clear in its orders that it was following the mandate of what it believed this court said in its prior opinion. And in addition, that doesn't really make sense with how that analysis is supposed to go. And is
that one of the reasons that your primary argument is that it's just a present tense impression and that's why it needs to go back or that anytime it's remanded for reconsideration, it needs to be a present tense impression, because then that takes it out of that statute and out of that?
Yes, that's right. It does take it out of that statute, though even here, and this is part of Father's argument, is that the court actually did do the 1108 analysis and did consider the additional evidence and decided that it would not affect her decree. And in that sense, that's against the clear weight of the evidence in this case. And the guardian ad litem will elaborate on this more, but that's one reason we believe that this court can not only reverse and clarify the law about the present tense analysis, but indeed instruct this court to terminate.
Well, let me make sure I understood what you just said. I understood that what the juvenile court judge did on remand was consider the evidence as of 2017, just went back and re-listened to the same evidence that was presented, gave a little bit more shrift like we instructed to the domestic violence history, and then came up with a new set of findings based on the evidence that had been presented to her in 2017. I didn't read her post-remand decision as having even taken into account in any way any of the new stuff that you folks were alleging had taken place since. Do I have that wrong?
That is certainly our reading of the juvenile court's decisions, but Father argues in his response brief that the juvenile court took the evidence into account under 1108 and did that analysis, admittedly off the record. It's not in her opinion, in her decisions anywhere. But that's Father's position, that the juvenile court did that analysis and was within her discretion to ignore that evidence, which we think is against the clear weight of the evidence in this case, given the nature of the evidence.
But I don't perceive, so let me, I guess I'm asking what's your position, because I understood your position to be that the court didn't take that into account in any way, shape, or form.
That is our position.
And I don't understand your appeal here to be mounting any sort of substantive or frontal challenge to the new findings. In other words, you're not saying these findings that Judge Jimenez put together are insufficient or unsupported by sufficient evidence. What you're saying is there's a procedural problem with how the court got where she got in terms of she did a past tense rather than a present tense analysis. Do I understand that correctly?
That's correct. And I believe the guardian will go more into some of the substantive problems with the juvenile court's decision, but that is our position. That it is a procedural problem. The court did the wrong analysis in the past tense rather than the present tense, and did not take into account that new evidence.
Yeah, in your blue brief, there's one issue raised, and that is, did the court conduct a present tense or correctly conduct a past tense and rather than a present tense analysis? There isn't an issue too in your brief about, well, even if it conducted the right present versus past, the findings it did make are unsupported. I don't see that argument in your brief, and I think I have that right, correct?
That's correct. We asked for that additional relief for the court to just terminate in the reply, given some of the even more development of what had happened in this case, but that's correct.
And I know your time is ticking down or has already expired, but if I may interpose one more question, just sort of practical question that, there may or may not be a decent answer to this, or may not even be relevant, but I'm just sort of curious. The position by the other side and by the juvenile court is that, hey, you can just file a new petition. You can just come in and file a new termination of parental rights petition and put all this stuff into evidence that way. You haven't done that, right? Do I understand that correctly?
That's correct. We have not filed a new petition, and there's several reasons for that. The first one is that it doesn't make sense under the way jurisdiction works with the juvenile court. Petitions are to invoke the special jurisdiction of the juvenile court. That's already been done here. These children are under the juvenile court's jurisdiction, and so the post-trial avenues to get that evidence in are the proper procedural mechanisms. Mother is not required to file a new petition, and in fact, filing a new petition will require re-adjudication of the entire case, including the unfitness prong. So it creates a substantial burden on the parties in the court to go that route when it is not procedurally required.
Thank you.
I was just going to follow up. Is there any concern that because this evidence was presented sort of in the middle after the remand, sort of post remand, is there any problem that maybe this evidence wouldn't, because it was known before a new petition would be filed, that it couldn't be used at that point?
So I think that question is getting to sort of the NRACL analysis and that. And with that is not a concern here because mother is in the same position as the state. So she could bring that evidence in a new petition. It's a judicial economy issue from that perspective. So there isn't that problem. And in addition, mother did request additional discovery, and the juvenile court is certainly able to manage that in terms of allowing father additional time to deal with new evidence that's brought up. And father can use post-trial motions as well to bring in any evidence that he believes needs to be heard, new evidence that he believes needs to be heard before the court. So there are a lot of ways to mitigate whatever might come out of the timing of the evidence. And this happens regularly in child welfare cases, as the guardian will elaborate on. So it's not a problem here. If there are no further questions, I'll yield the rest of the time to the guardian. Thank you.
Thank you. And we certainly did keep you over with our questions. So Ms. Pierce, you have your full 6 minutes for your argument.
Thank you very much. This is Martha Pierce, attorney guardian ad litem for the minor children. To elaborate on that last question, I want to say that it's very common in juvenile court to bring up evidence that happens as recently as the day before court. Parents do it all the time. They say, I've been clean up until now. So the juvenile court is very used to hearing evidence that, because it's such a dynamic, children and parents are such a dynamic situation. So this isn't a new situation to bring up evidence that's very recent. And if the other side needs time to address that, that's a remedy that can always be applied. Now, what I want to talk about are 3 substantive issues in the juvenile court's reconsideration order. There's 3 of them. The first is that the juvenile court erred by factoring in father's interests in the best interest analysis. And the second one is the court erred in failing to factor in statutory presumptions. And the third one is the juvenile court erred by failing to promote and secure the child's interest in terms of the legal structure that it left the children in. So dealing with the first one, the court privileged father's interest over those of the children. If you read the reconsideration order, it's primarily a set of safety planning. It puts up a lot of guardrails. That's what you do at the shelter hearing before you even adjudicate, while the parent still has their parental presumption. But when you get to best interest, it's not about guardrails. You get to ask, why are we even going down a dangerous road that requires all these guardrails? So it goes beyond safety planning, and it looks at welfare. It looks where can the child flourish, where can the child do the best. And the juvenile court consistently privileged father's interests over those of the children. The juvenile court also erred in failing to implement the statutory presumptions. And indeed, it said, I can't do that because if I did that, I would be speculating. But it's not speculating. Adjudication of abandonment presumes against reunification. And throughout the reconsideration order, the juvenile presumed in favor of reunification services. A finding of aggravated assault against the child's other caregiver places a duty on the state to file a termination petition. And while the state isn't involved in this case, that's a pretty clear signal from the legislature that there is a direct line between trying to kill the parent's caregiver and the child's best interest. So the juvenile court failed in those two instances to use those statutory presumptions. And yes.
Let me ask you a quick question about that. I'm not entirely clear on all the procedural niceties here, but I assume that the restrictions on visitation and things like that the juvenile court referred to the district court putting in place, are those part of the divorce case and child custody case? Is that where those restrictions came into play?
Yes.
So I'm just wondering if the statute about reunification services applies here where we're dealing with really custody determinations made by the district court in a divorce case.
Well, in a divorce case, both parents are presumptively fit. This isn't that case. And so the statutes under Section 30 that deal with divorce cases about reintroduction therapy don't really apply, because this is a case where one of the parents is unfit. And they're unfit because of abandonment. And abandonment is a unique ground because it shows that a parent has turned their back on their parental duties. And parental rights are a correlative of parental duties. So to rely on the divorce proceedings, I think, gives an inherently unstable structure to the children. And that brings me to my third point, that in Re BTB, the Supreme Court version, said that you're supposed to choose the dispositional alternative that best promotes and secures the children's best interest. And to me, secure suggests that we're talking about a legal structure. And the legal structure giving father non-custodial parental status is inherently dangerous to the children. He gets all the privileges of parenthood. He gets his constitutional rights. He's a presumptive parent in the event of mother's death or disability. And he gets to veto issues such as the children getting passports or a FAFSA application. He gets to do all that. And more importantly, giving father non-custodial status means the children's best interests are stymied, because what they want and what their best interest is to be adopted by their stepmother. And so long as he has non-custodial status, that can't happen. So he's getting all the privileges, even though he's turned his back on parenthood. So unless there's other questions, I ask this court to, yes.
It sounds like you, as opposed to mother, are in fact making a substantive sufficiency-based challenge to these findings. Is that right?
It's not a sufficiency of evidence so much as legal. These are legal presumptions that the court has to make. So yeah, I'm saying that the evidence is sufficient, and also that there's significant legal implications with a finding of abandonment, with a finding of aggravated assault against the caregiver, and with factoring in the father's interest. I think we have clear direction from the Supreme Court that you don't do that. So I think based on what the legal presumptions that I presented, this court can remand with instructions to the juvenile court to find that mother made her case going to grounds and going to best interests.
let's say we don't go that far, but let's assume for a moment that we're persuaded by mother's argument that it's a present tense analysis and send it back for the court to consider all the evidence. Do you believe that our opinion needs to go further and give the court guidance about how the best interest analysis is to be conducted?
I think you definitely do, because if you look at the juvenile court's analysis, it reads, like I said, it reads like a shelter hearing disposition. It factors, it's all about least restrictive safety planning, putting up guardrails, protecting father's rights, when at this point we don't even consider the father's constitutional rights under BTB. The juvenile court presumed in favor of reunification. You can't do that with abandonment. So I think just looking at that, it's very clear that the juvenile court does need guidance on this.
Thank you.
There's no question, then I'll submit it. Thank you very much.
Thank you. I see no further questions, so we will turn to Ms. Norman, who is representing the appellee.
Good afternoon, Your Honors. May it please the court. My name is Kirsten Norman, and I'm here appearing on behalf of the appellee and father in this case. It would be very fair to say that there are facts in this case that are challenging and complex, but it would be more accurate to say that all of the cases or all of the facts surrounding this case are challenging and complex. And because there's a very, very clear path forward wherein all of those facts can be fully examined in a proper best interest inquiry, we are respectfully requesting today that this court affirm the lower court's decision for two reasons. Firstly, because the lower court properly interpreted this court's directions in its first issued opinion in this case. And secondly, because the court was well within its discretion to deny mother's motion for a new trial. So to my first point, Your Honors, we're familiar with the decision that this court issued in the first case, indicating that there was a material flaw in the juvenile court's analysis. And we're also familiar with the direction this court gave to appropriately consider what effect, if any, father's history of domestic violence might have on his efforts to reestablish a relationship with his children. This court had a lot of options before it when it remanded, but the directions that it did give said to remand for proceedings consistent with this opinion. And this court also articulated, we do not, however, make any effort to urge the juvenile court to reach one conclusion or another upon reconsideration. And it acknowledged that the juvenile court's superior position and specialized training would enable it to make good supported factual findings from the juvenile court on remand. And those entered after adequately considering all of the proper factors, of course, are always entitled to deference by the appellate courts. And so that's precisely what the juvenile court did in this decision. She went back and she supplemented those findings with a 20-page order on reconsideration. And it went into a deep dive considering both the facts that had been presented and the research that had been articulated both by this court and by mother. And she gave her reasons why she still continued to believe that there were sufficient layers of protection in place, that these children were not subject to harm. And we didn't cross that threshold of clear and convincing evidence that it was still true that termination. Go ahead.
So isn't best interest always a present tense inquiry? I mean, I'd like you to hear your response to Ms. Marischal's argument there. The argument from that side is, look, based on the statute using present tense language, based on some of our earlier cases using present tense language, best interest always is supposed to be a present tense inquiry. We're supposed to look at best interest as of fall of 2019 on remand. We're not supposed to, in the fall of 2019, examine or evaluate best interest as of spring of 2017. What's your response to that argument?
If that had been the court's intention, that it would have clearly asked for a new trial. And the court has done that and has been comfortable issuing that type of remand in the past. Indeed, in its order on reconsideration, the juvenile court addresses case history from this court where the court has particularly exactly addressed the juvenile court to hold a new trial. It also indicates, yeah.
But that goes to my question to Ms. Marischal earlier, is aren't we dealing with two questions here, right? The first being, is it a present tense or is it a past tense inquiry? And we need to answer that question, and the three of us are going to need to answer that question. The second question is, after we answer that question, let's assume for the purposes of the question that we come to the conclusion that it needs to be a present tense inquiry. Then there's a separate question that I think would devolve to the district court, which is, well, how do I go about doing that present tense inquiry? Do I need to hold a full-blown trial, Or are these facts really undisputed that we can just deal with them in sort of summary judgment procedure? I allege them and you don't deny them. And that's going to vary from case to case. But in any case, doesn't it need to be a best interest inquiry? And when we say, just because we don't say new trial, that doesn't necessarily signal, I wouldn't think, that you wouldn't conduct a present tense inquiry. That's a long question. I'm sorry about that.
No, I understand your concern. And I'm going to actually jump to my second point because I think it addresses it more head on. In terms of what vehicle most properly enables us to have the proximity of time and the children's best interest, and that would be refiling the petition. So Rule 59 itself contemplates that the motion has to be filed within 28 days of the decision, right? The new evidence has to be very proximate to the decision that the court made in terms of best interest. Similarly, Section 1108 has to be read in concert with that. There is this timeliness idea that if we're artificially constrained by the time of that old request, then we're no longer looking at the ecosystem that the children inhabit currently, right? We don't have a clear picture of what their best interests are right now. And it's important to note that both the guardian's motion that was filed in this case and mom's motion were both made via Rule 59, which indicates that that motion has to be made no later than 28 days after trial. Well, that means we're constrained artificially to the events that took place within those 28 days. And now we're 4 years past that amount of time, and there's a whole world of evidence that exists that is important to a best interest inquiry regarding these children's current placement. And the most clear path to get at that information that's not narrowly constrained by amount of time or by what one party decides to file in Rule 59 is simply refiling the petition. And the juvenile court can take judicial notice of the things that were previously determined, like unfitness.
But isn't Ms. Marichal correct that, the filing of a petition in juvenile court in this particular circumstance, first is to engage the jurisdiction of the juvenile court. And the first inquiry, the first question is about the safety and the custody of the kids going forward. That's a determination that's already been made. Aren't we at the second phase? What good would really truly come from filing, sorry, my lights are turning off, from filing a brand new petition when we've already addressed, the initial inquiry that needs to be made?
The 4 intervening years and the needs of these kids being drastically different, the ages of these children being much older, they're now teenagers, and their interests have actually not been articulated to the court. They did not testify at trial initially. And so this would be an opportunity for now much more mature children to have their opinions on the record, along with all the other information that can be taken in with a full best interest inquiry that comes from refiling the petition. And we talked a little bit previously about, judicial economy and how there's an option that mother can use to file these post-trial motions. And then in response, father can also file post-trial motions. Well, JP itself talks about what seems like the more efficient remedy. And at this point, the more efficient remedy truly is refiling the petition. And again, taking judicial notice of the things that are well established. We don't have to reopen the door on unfitness. The judge can take judicial notice of that being established. And we can just focus on this inquiry of being in the children's best interest. What is truly in the children's best interest at this point when we do a holistic review as we're required by INRI BTB? I think it's important to look at the significant amount of time and attention that the juvenile court judge gave to BTB in her order upon reconsideration. She indicated, and she quoted this court, and this court has now subsequently been quoted by the Supreme Court of Utah, indicating that you have to start in these cases from the legislatively mandated position that wherever possible, family life should be strengthened and preserved. And then a court may terminate parental rights only when it concludes that a different option is in the child's best interest and that termination is strictly necessary to facilitate that option. If the child can be equally protected and benefited by an option other than termination, termination is not strictly necessary and a court cannot enter termination. Additionally, and the Supreme Court indicated that this court very eloquently stated this next portion, the court is obligated to explore whether other feasible options exist that could address the specific problems or issues facing the family, short of imposing the ultimate remedy of terminating parental rights. And courts should consider whether other less permanent arrangements might serve the children's needs just as well. That is what the juvenile court judge did here. She determined, again, that there were enough layers of protection between the children that they were not subject to harm from go ahead.
You said that exact same quote earlier, and I wrote it down because I wanted to ask you a question about it. When you talk about that there's sufficient layers of protection, the children wouldn't be subject to harm. Is that really a best interest inquiry? It almost sounds like, well, how detrimental would this be to the children to maintain the parental rights? And in Re BTB, the Supreme Court was very emphatic that the best interest analysis is always from the child's point of view. So do we potentially have a problem here with the way that the juvenile court articulated or at least applied the test, that she was looking more at mitigation of harm, as the guardian ad litem argued, rather than actually the best interests of the children?
I want to clarify, it's absolutely correct that this is an inquiry that is conducted from the point of view of the children. But what we're not talking about in these cases ever is examination of behaviors of a perfect parent who never did anything wrong. We are always looking at a scenario where there have been challenges, and we're looking at whether there are sufficient protections in place that the challenges are not harmful at all to the children. And the children, this is what's important about that best interest inquiry, they can continue to benefit from leaving the relationship in place. And that's what the instruction is from BTB. Are there a less permanent, and there's actually language in Re BTB that talks about allowing to rehabilitate the relationship, an option short of termination that would enable the children to continue to get the benefits that are derived from that relationship remaining intact. I think it's important to note, too, that there were facts on both sides of the ledger in this case. This was a close call. This was not an easy call. And there's not the clear weight of the evidence on one side or the other of the ledger necessarily, because there were facts that spoke against permanency in terms of this is the option that was laid forward by mother doesn't actually necessarily guarantee the children the permanency that they were seeking at that point in time. The judge was not persuaded by that information. But what BTB allows is for that opportunity for rehabilitation to continue to benefit from in the relationship. And this is not just connection that it provides to a single parent, but it's the connection that it provides through that parent to a community, to cultures, to the resources and the world of people that parent is connected to. It's not just the parent in a vacuum. And I think that concern was really eloquently articulated by the juvenile court in saying that she had a very real concern that if this particular relationship was severed, these children would no longer have an African-American person in their life, particularly an African-American male person in their life. And she also went on to, when she was discussing the harms that children experience when one of their parents engages in domestic violence behavior, as those particularly being concerning when the children have the opportunity or are in such close proximity that they maybe model that behavior. And she gave the reasons in the opinion where she stated because of the way that the district court order exists, these children are not going to be in the custody of their father. They are only going to be introduced to him via therapeutic reintroduction if that's in their best interest. And so what the judge did was, when she got to that point of this case where she determined that the evidence was not clear and convincing, that termination was absolutely in their best interest, and that there was an option short of termination that would allow for them continue to be safe, well cared for, and allow their best interest to remain at the forefront of the case, She left open this lesser option that allows the children to pursue that relationship if they wish to. It's really the avenue that allows them to go via reintroduction therapy and have an opportunity to have a relationship with their father that they would not otherwise be able to have.
What's your response to Ms. Pierce's argument that one of the things that this does, however, is if the mother were to pass away, that the father would be the presumptive parent, and that is maybe something that should be considered in terms of whether it's in the children's best interests?
Well, the children can't be in the care and custody of the father presently, and the district court order doesn't say that they automatically go back. It says that reintroduction therapy is required in any instance. But this also demonstrates another instance of why refiling the petition would allow us to take notice of the facts as they exist presently, as they are right now, and it would give us as wide a lens as possible to be able to investigate all of the things that speak to the children's best interest. And that's what BTB and the cases that have come in its wake really speak to, are that totality of circumstances that we're really supposed to look deeply into for children. And so for these reasons, unless there are any further questions, we respectfully request.
Yeah, so you keep coming back to this present tense inquiry, and it seems like you agree that the best interest analysis should be a present tense one. Do I perceive that correctly?
When it's conducted by the juvenile court, it should be it's one of the reasons that Rule 59 isn't always the best vehicle for engaging in a best interest inquiry, because Rule 59 is artificially limited in time. Whereas if you refile the petition, you are able to have a present tense best interest.
I guess I'm having a hard time understanding why you think in a post-remand world we need Rule 59. Right. So in this case, in 2019, we wrote an opinion that said this needed to go back for reconsideration of the whole best interest analysis. The judge is going to have some discretion as to how that unfolds, but what the judge needs to do is re-grapple with the best interest analysis part of the two-prong inquiry.
I think what's important.
That's got to be a present tense inquiry, doesn't it? And so why do we need to deal with Rule 59? There's nothing. It's an appellate court ruling that's come down. There's no district court ruling that needs to be sort of altered or amended through Rule 59. There's an appellate court mandate, redo this, set a date and do it. I don't understand why we're even talking about time limitations in Rule 59, and I don't understand why we can't just do that present tense inquiry in the context of a post-remand proceeding. Can you help me understand that?
Absolutely. I'm just going to try to do it succinctly as I can. So Rule 59 is useful for parents who become legal strangers to the children if their rights are terminated. It's the only vehicle whereby a parent who has had their rights terminated can then introduce new evidence that speaks to a concern that indicates that the decision was incorrect and when it was made at trial. There's not another avenue. The parent certainly can't come back who's had their relationship terminated by the court. They certainly can't come back at that point in time and repetition or anything. There's no vehicle for them to do that. So Rule 59 exists to provide a parent that avenue. And if the instruction from this court was on remand to engage in a full best interest inquiry, I think we would be supportive as well, because the same facts speak. We're indicating we're not trying to prevent any court from looking at important facts that have transpired in the wake of this case. We're just indicating that lens should be as wide as possible to be in concert with the values that were articulated and the policies articulated in BTB about a holistic inquiry into the best interest of the children.
Okay, so if we were to say that what we meant in paragraph 25 of the previous opinion is that we wanted the district court to basically redo the entire best interest inquiry, you would agree then at that point that needs to be done in a holistic way and new evidence needs to be considered.
Yes, I don't see how anybody can reasonably articulate that when you're doing a best interest inquiry that it should, be on stale information. However, again, refiling the petition is the more common way to accomplish that. I think it's important to consider when a parent actually wins one of these cases, and I'll be brief. when a parent is successful in not having their rights terminated and that case is then appealed, to kind of leave the door open forever until this court has issued its opinion wears away at the very permanency that we're trying to assure in these kinds of cases, where we're saying that we have given such a level of deference to these cases because we want to assure that the parents and the children, especially, a measure of certainty. So if we're saying that every time a case goes up to appeal and it's remanded, unless there's a specific instruction from this court to hold a new trial, essentially we're not really offering those families permanency, and we're not offering them relief from investigation and constant kind of observation and interference by the courts if we leave that door open. So if there are no further questions, I respectfully request that this court affirm.
Thank you very much. And who will be presenting rebuttal, or are you going to, you're not going to split the time, I assume? All right. Whenever you're ready. Thank you.
I'll just pick up on where the court's discussion was just there. So one glaring problem with the requirement that mother has to file a new petition in order to get this new evidence in is that it effectively eliminates this court's ability to remand in the cases where a parental right has not been terminated. Because if every time this court remands for reconsideration of the best interest analysis, for example, when there hasn't been a termination, that's essentially what father's arguing, is that you have to file a new petition. There is no other way to get the evidence in. A lot of the discussion was centered on Rule 59, and it's important to note here that that was not the only vehicle that mother used. Mother moved to amend her petition. That was rejected by the juvenile court. Mother also moved under Section 1108, which does not have a time limitation. It says at any time in the statute. So those vehicles are perfectly appropriate, even if Rule 59 might have some limitations that mother does not meet. Those other vehicles were definitely appropriate to do so. And finally, the idea that a new petition opens the door wider for more inquiry or does a better job of taking into account all of the factors is not well supported. It's not clear at all that new evidence, even in support of father, can't be brought in through reopening discovery, which the juvenile court can absolutely do after a remand if it chose to do that. And even in other post-trial motions, if father can't use Rule 59, he can use 60, he can use 1108, he can use any of those vehicles that mother used in this case to get that additional evidence to come in. There's just nothing that restricts that. And as far as taking judicial notice of the prior adjudication of unfitness, the Supreme Court in Re ACM has already expressed great trepidation about the res judicata effect of prior adjudications on future petitions in the context of parental termination, precisely because of some of these problems with having to consider the current circumstances. So even though the court could take judicial notice of its prior abandonment finding, that does not guarantee that finding will stand, and it will be relitigating the entire case.
I don't mean to belabor this point, but I just, again, am wondering, why is it necessary for mother to use any of those vehicles in this case? I mean, this is a case that is still pending, and this court vacated the court's order, sent it back. At that point, do things actually need to be reopened? Does there need to be a motion for a new trial? Does there need to be a motion to amend the petition? Or is it simply that the court simply has to conduct a best interest inquiry on present tense information?
That's correct. There is no need to use post-trial motions if the court is doing the correct analysis, which is under a present tense inquiry. Once this court remands, that should be the strategy that the juvenile court employs, and it should be seeking out new evidence, or at least open to new evidence. Mother just used those avenues as a way to ensure that evidence was before the juvenile court, but it is absolutely not necessary. If there are no further questions, once again, we ask this court to reverse and remand with instructions clarifying that the best interest analysis is in fact a present tense analysis, and terminate father's parental rights. Thank you.
Thank you. And thank you all three of you, for your arguments today. They were very helpful. We appreciate your preparation and your thoughtfulness about answering our questions. And we will take this matter under advisement and issue a written opinion as soon as possible. We will be in recess until 3 o'clock.